And welcome everybody to the 14th edition of the Deserve to Win podcast. As always, I'm your host, Eric J. Troutman, the czar of the TCPA, coming at you from our new awesome cool studio with like the Deserve to Win sign in the background. What do you think, co-host Pooja?
Oh, it looks amazing. We have two guests back here too, apparently.
They're not guests. Whoa. These are features, but we have to throw it around. But welcome, Pooja, to the co-hosting episode 14. Who's our guest today?
Who's our guest? Abbas Kazerounian of the Kazerounian Law Group.
We're gonna have that guy in person.
He's coming in.
I'm excited. I'm really.
Is he our first guest to our office?
Yeah, he's the first person that's like an opposing counsel, certainly, to see our new office. Our first in-person guest since Adrian Bacon at the old studio. So I'm super excited. But you're right. We should introduce ourselves. Pooja, of course, you've already said hello. So why don't we start with you, the dame?
Hi, my name is Tori Guidry. I am the dame of TCPAWorld and an attorney at Troutman Amin LLP.
You're really getting that down, Tori. Very well done. Remember the first time she'd introduce herself, it'd be like mumbly fantastic. I love it. Looking great, Tori. And who are you?
My name is Brittany Andres. I am the Baroness of the TCPAWorld, and I am an attorney at Troutman Amin.
Fantastic, thank you. And now in seriousness, who are you, dark brooding individual? Who are you, man?
How you doing, everybody? My name is Joe Zanetti. I'm the Viceroy of the TCPAWorld. I'm also an attorney at Troutman Amin.
The Viceroy, fantastic, powerful title for a fantastic, powerful attorney, former AG, former district attorney, Joe Zanetti, a real fighter. Love this guy. You're Viceroy. And the principal now in the New Orleans office, however you pronounce that, Louisiana, NOLA, where Troutman Amin LLP has its newest office. Joe, it's fantastic to have you. Give me a round of applause for Joe. It's great to have you here, man.
Good to have you here, Joe.
Take a bow.
It's real power. The guy's tried over 100 cases. I mean, he really adds just tremendous strength to an already incredibly powerful team. Troutman Amin, we just keep going, we keep winning, we keep growing. But we're missing one person, which is this lovely lady behind me.
Hi, my name is Angelica Munger. I'm the Duchess, and I am the paralegal here at Troutman Amin.
The fantastic Duchess, who is really the wonk when it comes to everything state privacy. We've got now resources in all 50 states. It's incredible, and it's all thanks to Pooja. No, I'm kidding. It's all thanks to Angelica. It is absolutely fantastic to have you. All right, so you've got all of us. We've got to rush here. I think Abbas is going to be here in like 10 minutes. So let's start breaking down the news. Look, I'll go first. Last episode is kind of funny. We had so much to cover. We didn't cover what's arguably the biggest news in the last 3 months in TCPA world, which is the amendment to the Florida Telephone Solicitation Act, the FTSA. As all of you know, just like 2 months ago, that was the most dangerous, quote-unquote, mini TCPA in the entire country. Extremely broad definition of auto dialer. Essentially any phone, anywhere was going to be treated as an auto dialer. It was just brutalizing people when it comes to text programs, right? These text clubs that people would send out text messages. At the federal level, of course, text messages were not actionable essentially after Facebook. But in Florida, they were driving massive litigation under the FTSA. All of that has come crashing down. That is no longer the case, Pooja. Florida has gone from arguably the strictest anti-robocall state to now maybe the loosest robo-text state in the entire country, with a 15-day notice requirement that has to be honored before a class action can be brought, before a suit can be brought. So for instance, if you're receiving unwanted text messages in Florida, you have to say stop, and then you have to wait 15 days. And only if on that 16th day the caller continues to send you a text, then and only then will you have an action bringing a suit on the FTSA from a text provision. Not only that, when it comes to phone calls now, right, previously you recall very broad definition of an auto dialer that included any system that could either select or automatically dial numbers. Now the system has to both select and it's a very important and dial numbers. So whereas before, essentially any system, right, unless it was a very advanced human selection system, would be an auto dialer, now really only your pure predictive dialing systems are going to constitute auto dialers, whereas your click-to-dial systems are now going to be essentially immune from liability down there in Florida. Plus, this is huge, now the auto dialer provision only applies to unsolicited calls, right? Previously, you might recall that there was no EBR defense, there was no inquiry defense. You had to have very robust express written consent in order to be able to state a claim. Now, again, ATDS definition, auto dialer definition narrowed, and you've got an EBR defense and an inquiry defense because the definition of unsolicited is pretty narrow. Now, we don't know, this is, I guess, the one open question, something to think about, Britt. We don't know if the EBR is going to align with the federal EBR standards. We don't know if it's going to be 90 days inquiry, 18-month transaction. It's not defined in the Florida statute, the Florida code. So we're going to have to wait and see. The case law is going to have to develop there. Nonetheless, really positive development. And we're seeing, of course, a shift immediately how fast the plaintiff's bar moves. We saw last time we talked to Frank and Tab. They were saying, Oklahoma, right? Oklahoma, here we come. This is what everyone's looking at because, of course, the OTSA, the Oklahoma Telephone Solicitation Act, has the same provisions as the old FTSA. It has not yet been amended. People seem to be confident that it won't be. I don't know about that. But for now, it's certainly live on the books. Broad auto dialer definition. Really, really important, massive change to the law. But, Mr. Viceroy, coming straight to you, man. Hope you're ready. The FTSA is not all the way dead, is it?
It's not. And while that definition has been extremely changed, there has been an incredible change in the law on that. Charming Worm, actual name, actual person.
Charming Worm.
Looked her up the other day, I think.
I thought that was my DJ name in high school.
Well, I didn't want to out you like that. But there has been a new lawsuit filed, and they're trying to get around the 15-day notice by the caller ID provision of the FTSA. And it's going to be interesting to see what happens and how it goes down. I'm not sure if it's going to turn on a predominance issue or if they're going to have to take this back up, but it's still alive.
What's the theory, though? What's the theory of the claim? Isn't this like a shift now to the caller ID utilization, or is it still an auto dialer / text issue?
It's an auto dialer / text issue with the ID to get around the 15-day notice. They're saying that plaintiff Worm tried to call the numbers back to no avail, and that's what they're staking in their complaint.
There's an early bird joke here somewhere. They're going to get the worm. I haven't solved it just yet. It'll come to me by the end of the show, I'm quite certain. But you look, so that's something to keep in mind, right? The plaintiff's bar, highly creative. They're pivoting. We just talked about they're moving over to Oklahoma, looking for claims under OTSA, but they're also pivoting to other sections of 501059 of the Florida Code, right? They're looking specifically now at the provisions related to telephone identification. And when a telephone number is provided over the phone, right? So you make an outbound call, the phone number comes in, the consumer has to be able to call back on that number. Now that's fine with calls, but with text messages, as we all know, short codes, right, are not phone numbers that are capable of return calls. And many times today, people are using 10DLC registers through the PCR, and those don't call back to a call center either, and you'll actually get an error message if you attempt to call back that phone number. So since you've got text messages being treated as calls under the statute, and yet text messages are being sent over a medium or using phone numbers that are not always permitting an inbound call, you've got real tension with the provision of the statute that requires all outbound numbers to permit inbound calling. Really fascinating theory, actually. I'm not saying that the worm, charming or otherwise, is onto anything, but this is something we need to pay really close attention to. Great stuff, Viceroy. Appreciate having you here, man. Really excited for the future and glad you're with us. Something to look in this direction. Baroness, what do you have?
Yeah, so I have a case that was just filed in District of New Jersey. This is the case Doyle versus Matrix Warranty Solutions.
Oh, great case, yeah.
In response to the complaint, the Matrix moved to dismiss, arguing that the allegations were insufficient to hold Matrix directly liable for the call because it didn't make the call, and also they couldn't be held vicariously liable for the call. As you folks know, a plaintiff may recover under a vicarious liability theory under the TCPA. So even if you're not directly making a call or text message, you can still be held vicariously liable. A business can be held vicariously liable under 3 theories. The first is if the agent has actual authority to act. The second is if the agent has apparent authority to act. And the third is if the business ratifies the agent's conduct. The court's analysis on the vicarious liability issue wasn't as compelling. They ultimately found that the allegations were insufficient to hold Matrix vicariously liable. But what's more interesting was the direct liability analysis. So plaintiff argued that matrix and the third-party element were essentially the same. So they had the same address, they operated, I think, in the same suite, they had offered similar services, their website names were similar. So the court ultimately denied the motion to dismiss, finding that Matrix could be held directly liable for the call.
So that's an amazing outcome. I mean, just think about that. The court finds that there's not sufficient allegations for vicarious liability.
Right.
Yet the court finds that there's sufficient allegations for direct liability. In other words, there's not enough allegations that the third party that made the calls is closely connected enough to impose vicarious liability, yet somehow the court finds that they're closely connected enough to impose direct liability as if the defendant itself, as if Matrix and Element were the same entity. That's bizarre. I'm going to tell you, if you look at, and maybe we'll get like an AI program to do this. If you look at the history of the law, I'm going to guess that there has probably been less than 5 in history cases where a court found vicarious liability was impossible or insufficiently pled, and direct liability was sufficiently pled. A remarkable case. And to me, the most remarkable part, which you didn't mention, Baroness, I'm a little disappointed, is the finding that the court looked at the fact that on Element's website, it referred the legal department. The lawyers were the same, right? That is what the court found most compelling, was that the email address for the lawyers was legal@Matrix on the Element's website. So essentially, the Matrix legal department was stepping in as Element's attorney. And that the court found to be incredibly impressive, that, essentially saying that the care that a lawyer has to have to distinguish between clients informs me, the judge, that this must be the same party, because obviously the lawyer wouldn't try to represent two parties that had divergent interests like this, not in a public setting. Now, from my perspective, the problem with that, even if I agree with the ultimate conclusion, is that the fact that Elements had that email address on its website does not mean that Matrix allowed it to do that, right? It doesn't mean that Matrix even knew that Elements was doing it, much less that Matrix was in fact serving as legal counsel or using shared legal counsel with Element. Nonetheless, that's what the court used. I thought it was a really, really interesting piece of the ruling. But nonetheless, great job, Baroness, and great job in court today, too. She was in court. None of you got to see it, but I did. Very fantastic advocate. Great work. Pooja, what do you got?
Oh boy. So new state privacy laws. I'm going to pivot a little bit off of TCPA. So now, currently pending, we have 11 states that have privacy laws that will be flowing through all the way to 2026. On TCPAWorld.com, we now have a new state privacy law resource website, so I encourage folks to check it out. But so Connecticut and Colorado went into effect on July 1st, 2023. Same time, the CIPA, if you recall, amended the CCPA that's been implemented in California for a few years now, was intended to go into effect on July 1st, 2023 as well. However, the California Supreme Court said, no, we're pushing it back to now March 29th, 2024.
Why did they do that?
So the chambers had brought suit against the California agency, letting folks know that the final regulations had been implemented, finalized 8 months past their deadline. So you get a year, you get 12 months after the finalization of the rules for folks to start having to abide by those regulations.
So someone missed the deadline.
Probably. What's the key takeaway here, though, is folks have 9 months now to kind of get their procedures in place and compliant with now the CIPA, but keep in mind that the AG's office, the California AG's office, still they can still come after you and still file fines against you, regardless of those 9 months.
Under the CCPA.
Yes, correct. So the CCPA's key provisions, right, the right to opt out, for a right to know, the right for a consumer to request more information, all of that still stands, right? And AG's offices are still paying close attention to that. So just keep in mind, these state privacy laws are flowing quickly, extremely quickly. Some of them have private right of action, some don't. Usually it's for data breaches and whatnot that the private right of actions exist. But regardless, the AG's office holds all the power to enact these state privacy regulations.
How can people find out more about state privacy regulations that might impact them?
go to tcpaworld.com and click on the state privacy website.
Well, there's that, but I was going to say call Pooja.
Or call Pooja, yes.
Yeah, that's what I would do. All right, thank you, Pooja.
Yep.
And how about you, Tori? What you got?
Well, last week I covered the AI case with OpenAI, where it was sued by 16 unnamed plaintiffs. Well, this week there's another lawsuit that was filed on the same exact day, same exact court, Northern District of California, where now two named plaintiffs, Tremblay and Awad, are suing OpenAI for copyright infringement. And essentially these, OpenAI has the program ChatGPT. And ChatGPT is run by two softwares, GPT 3.5 and GPT 4. And those softwares are trained using data sets. And they're claiming that in the data sets used to train ChatGPT included their books. Both of these plaintiffs are authors of books that are claiming that their copyright was infringed upon by this training.
I don't understand that. I mean, if I read their book, I haven't violated their copyright, right? So I've got TCPAWorld.com, thousands of fantastic free, barrierless articles to really keep you and your AI puppet informed about the TCPA. But if these things are read, right, of course I maintain copyright, I maintain license, but people can read them just fine. Mm-hmm. Why can't OpenAI read these books? Is it because they're repeating what is in the books to somebody who asks, or is it the act of reading itself that somehow violates the copyright?
I think it's because they're profiting off of their works in a way by being able to ask these questions about it, being able to summarize it, and they're using their works to make money for their own company.
I think that's really well said. All right, anything else?
That's all for me.
Okay, you're really diving deep into the AI. I'm looking forward to, I know by the time you folks see this, this will already be passed. But in 2 days' time, or 3 days' time, we're going to be at the conference, the big Law Conference of Champions, the Troutman Amin Summer Marketing and Advertising Law Conference. I know you've heard all about it already. If you didn't make it, I'm sorry. If you did make it, awesome, right? And I'm really looking forward, Tori, to your big presentation on AI. I think it's going to be sweet. I'm really looking forward to it. Okay, last woman standing, the Duchess, the powerful, powerful Duchess, in from Arizona. So good to have you here. What do you got for us, Angelica?
Well, I feel like I should like strum a guitar and sing. I cannot do either. So I'm just going to talk to you about the FTC putting out a consumer advisory on Friday, July 7th. This is after the Supreme Court kind of struck down the student loan forgiveness program that the Biden administration was trying to push forward. There were 4 states that kind of came forward and they said, oh, no, not so fast. So it went to the Supreme Court, they struck it down. But at times when things like these are going on, it's a great opportunity. I don't know if it's a great opportunity. People are opportunistic, let's say it that way.
It's a great opportunity to commit fraud. Thank you, Angelica.
That's not what I would say. Some data guys seize the opportunity to kind of take advantage. And so the FCC wanted to get in front of consumers and let them know, like, hey, be on the lookout for this. Here are some key signs that people use. Here are some kind of language that they say where they're calling from. You know, don't fall victim to these scumbags, essentially. So there's some great pointers on TCPAWorld, and also check out the FCC too.
Well, what's fantastic about this rule, well, opportunistic, fantastic, choice of words. But what is really fascinating, I think, is that everyone's paying very close attention to this ruling, not from a consumer perspective, but from a carrier and from a call center and business perspective, right? This is essentially the FCC firing a shot across the bow of anybody who's using any message to communicate really anything about student loan programs right now. And if you're a carrier, man, you are on notice. And so if you are letting people continue to send messages truthfully, true or not, regarding student loan programs, man, you've got to be very, very careful. This is how it starts. It starts with an FCC advisory to consumers. Next thing you know, you're going to be reading about FTC or FCC press release naming carriers that are bad actors, or maybe naming specific individuals that are bad actors. Then, as we saw with the MV Realty phone burner disaster and with the global UC disaster, then you see the shutdown order, right? So we're starting to see the progression, right? And this is, right, the top of the funnel outcome here, just letting everybody know, hey guys, we've seen a lot of fraud out there, directed to consumers, but the businesses and the carriers had better be paying attention because they will not be far behind. But you know what I hear right now? I hear Abbas knocking on the door. We better go let him in. And now, to the power of the Troutman Amin LLP firm, we bring you our interview with Abbas Kazerounian, the Godfather of TCPA class actions. And now, through the power of Troutman Amin LLP, we are so incredibly excited to have live and in person in our studio the Godfather of class litigation in the TCPA, Abbas Kazerounian. Welcome to the show, man.
Thank you. Thanks for having me. Thank you.
Honestly, I mean, I think I started litigating TCPA cases, so I guess it was against Josh, but like you were like right within literally a year, probably within a month of litigating against Josh. I started litigating against you back in was it like 2008 or 2009? It was like a million years ago.
Yeah, that's when it was like the hot new thing.
Yeah, it's funny because I still think of us as young guys, but you know what? Look, we're just not anymore.
No,
and we're
all the grays are in.
We're getting up there, as the grays would say. But welcome to the show, man. I always love talking with you. And Pooja, I know you're going to be cross-examining Abbas here and really making him sweat. But why don't you just catch everybody up, man? What have you been doing the last couple of years? Like, how's your shop going? What are you guys focused on these days?
Yeah, I mean, that's kind of a loaded question, but without giving too much of the secret sauce away, I mean, obviously, I think we all know since the Facebook decision, the TCPA has kind of come to a place where it's not as, fruitful as it once was. So we're still doing TCPA, but we're doing predominantly like DNC and pre-records, which I think we've been discussing before the show, which, I would say 85-90% of the docket pre-Facebook, and even today, most of the calls were what we back in the day used to deem ATDS calls. And so I think the docket is probably shrunk by about 90%, and I think that's reflective of the number of TCPA cases my shop is bringing. But even in before that, we would try to be, somewhat diversified. We weren't purely a TCPA shop like some of, our competitors. So we've got a pretty thriving labeling, and we have an in-house biochemist. We do a lot of labeling cases. We do a lot of FCRA, CIPA, CETA, ID theft, FCRA, even FDCPA cases. We have different departments. We have the individual consumer cases, and I think we've litigated just on individual cases before too. And of course, the class action, department at the law firm, when, we do a lot of unfair competition, anything from, during the pandemic, there were a lot of idiosyncratic, unique cases like the refund cases. I'm a lead counsel on the co-lead counsel on the CSU cases. There was a forbearance cases with Wells Fargo. So we have a very diverse practice. I mean, with the exception of, I would say, securities and antitrust, if it's in the consumer realm, we're doing it.
It's amazing. And you started the firm. So walk me through the history here. When did you start the firm? It was just you and your cousin or your brother or something,
He's
right?
my nephew.
Your nephew.
Yeah, he's just a year and a half younger than me. That's correct.
Yeah.
So straight out of law school in 2007, I passed the bar and we set up shop in a coffee shop in Seattle's Best in Irvine, on the corner of Walnut and Culver. And for the first 3-4 months, we would literally come in every day, order one coffee and nurse it. And I was using my Boost Mobile flip phone for the central line. The barista, Molly was her name. The call would come in, I would throw it to her. She'd pick up, Kazerounian Law Group, how can I help you? And so we were taking anything from domestic battery to DUIs. And then I just knew that I wanted to specialize in something, and I just didn't know what. I just knew that I didn't want to be a specialist in PI, though ironically we have a PI department at my law firm now. That wasn't what I wanted to specialize in. And then one day, this guy walks in and says, hey, I heard you're the dodgy lawyer in the coffee shop. And I was like, yeah, that'd be me. And he said, well, I got got sued by Capital One. And I was like, okay. And he goes, everybody wants $250, $300 an hour. And if I could afford that, I'd pay the lawsuit, because the total amount the guy owed was $4,000 or something. I was like, I tell you what, give me $500. I'll take this to trial if it needs to go. And he's like, okay. So he goes to the cash machine. That's an ATM. So he goes to the cash machine and he comes back and he gives me $500. And we do the whole retainer on the back of a napkin. And I file the answer, send the discovery, and then 2 weeks later he calls me and he says, I'm a little confused. Don't you represent me? I said, yes. And he goes, well, these guys are calling me. And I'm like, there's something weird about this. So I go to the law library because I couldn't afford Lexis or Westlaw. So I go to the law library and I find this thing called the Rosenthal Act. And then I discovered the FTCPA. I sue Capital One, and like the guy, his debt was waived. He got $1,000 in his pocket, and then we made like $6,000. And I was like, this is it. So we started suing debt collectors. Next thing I know, I'm in federal court getting a bunch of published decisions. Then that obviously progressed into TCPA. And then next thing you know, we've got like 25 lawyers and we're class action practice, and here we are.
I was going to ask you, how many lawyers do you have?
We're about 25, give or take. Yeah.
And then are you just in California now, or have you spread?
No. We're pretty diverse in our geography. So we have 2 lawyers in Nevada, in Las Vegas. We have 2 in Arizona. We have a Seattle, Minneapolis, Dallas, New Jersey, New York.
Well, it's amazing. You started with these humble beginnings. We're here in our not so humble beginnings now. I mean, we've progressed pretty quickly, I think, rather rapidly. But when I think of folks in this community that is TCPA world, that is, consumer financial defense or consumer protection, I mean, you're the guy, Abbas. When I think of lawyers, I mean, you think of like Jay Edelson, but he's more on the privacy side. When you think of folks that really know the law inside and out, I mean, you're the guy. And so it's amazing that the story you just told me. That's incredible.
I appreciate it. I mean, a lot of hustle involved, as you probably know. I mean, I don't think knowing the law or being just a good lawyer conceptually is ever going to be enough in either side of the V. You need to be a hustler, and you need to grind, and you need to put in the hours. And I think the people that have any success on either side of the V have to have that trifecta.
Well, that's incredible. Pooja, what are you thinking here?
Well, I just love the story of the napkin because, as you know, Baroness was hired on the back of a napkin.
This is true.
All good things happen with the napkin contract.
Well, I just can't believe it that your first case was literally a guy who you took the case for $500, Abbas. That's incredible.
Yeah.
I mean, that really tells you kind of where you were right in that practice. You're sitting there like literally nursing a cup of coffee in order to get the Wi-Fi, right?
I mean, listen, I had a 1998 Toyota Corolla with 170,000 miles on it, and when I started that law firm, I had $200 in my pocket. But that was after law school, after I passed the bar. That is all I had. I didn't even have next month's rent. I didn't have my car insurance for next month. I had no health insurance because it was legal not to have health insurance back in those days, and et cetera, et cetera. I mean, like literally, I had zero. And I think that was one of the people were like, well, you're crazy. And I'm like, and the response to that is, I had nothing to lose.
It's a good point. I mean, and 16 years later, I mean, I know it's bad form to talk about revenue. It's bad form to talk about all your wins. I'm not going to do that to you. But I mean, without question, you have got to be, one of, I can say without question, one of the most successful consumer protection attorneys in the country, by any measure, whether you're looking at a revenue standpoint, at a settlement standpoint, at a, impact on the law. I mean, you're famously the guy behind the Marks decision, which in TCPA world just etched you into history. Well, along with the fact that you basically, along with Josh Swagger, invented the idea of a TCPA class action, which I swear, even to this day, I tell you, these things should never have been certified. But I mean, your mark on this area of law, I mean, it really is remarkable. You're the godfather for a reason. It's a great story, man. Thanks for telling us about that.
Of course. I appreciate all your kind words. It means a lot.
So tell me about the CIPA cases that you're bringing now. I'm really curious about this.
Sure. So, I mean, I'm a little bit more discriminatory than some of my brethren on the plaintiff side of the V. I know that the Ninth Circuit has said what it said about the chat box cases, and I'm not saying I don't do those cases or I won't do those cases. I'm very, very selective. And I'm a big proponent of what we taught in law school, bad facts equal bad law. Yeah. They're just not sexy. I mean, like if you think about, sooner or later someone's going to try and get the intent of the statute into play before a judge, right? So you've got this statute that was enacted in 1967 when the internet didn't even exist. So I know that's going to be the forefront of one of the issues that's going to get, to the California Supreme Court at some point, in my opinion. Yeah. And so I don't, I just don't want to push these cases because though technically we're right on the law based upon Ninth Circuit rulings, who are not going to be the top authority on this, because if I were on the defense side of the V, I would be pushing this on the state side.
Sure.
And so, defense firms and defense counsel can't help but remove, right? There's this propensity that let's get this in federal court. And that has its advantages. You've got the whole standing issues and all of this stuff that's going for you, but the case law isn't good on the federal and on the substantive law.
Well,
right?
until we get a hold of it, by the way.
Yeah, sure.
Trump and Amin has not yet made its mark, but we're going to. I see Baroness over there. We've got something cooked up, I'm telling you.
Yeah.
But keep going, sorry.
Yeah, she's flipping tables over there.
That's right. That's exactly right.
So like, I like those, but like I said, I'm being very, very discriminatory. And so the kind of case, I love the cell phone cases. I think the cell phone cases are where CIPA really, really shines, because you can certify those cases. And I had a case against a very, very big mortgage servicer which got settled, and on a tentative I had that certified. And the thing is, where most people think that we have a policy and procedure to give the warning,
right.
So it's an anomaly. You're never going to be able to certify it. I have the blueprint on how to certify that.
How do you certify that?
I'm not going to talk about it. You're going to use it against me.
Oh, of course.
I know how to certify that. In fact, off the record, I'll share it with you.
Okay, that's fine.
But on the premise that you can't share on your podcast.
Oh, come on.
No.
All right, we'll keep it secret. Look, my journalistic integrity, I will keep my secrets off the record. But
well, we're screwed then.
but that's a good point. But I will say, let me ask though, wasn't there recently some at the appellate level on the 632 cases, what we're talking about now under CIPA? So understand, of course, there's 631, which is your wiretapping, eavesdropping provisions, and then 632, 632.5, where you're looking at the secret recording of a cell phone communication or a confidential. 632.7.
Yeah.
Is that where you're pursuing the 632.7?
Yes.
Yeah, because there was some case law recently, I thought, that kind of limited the scope of the confidential communication provisions. And at one point it was almost killed, I think.
Well, the 632.7 has no confidentiality provision. That's what differentiates it from 631 and 632. 631 and 632, you have a confidential aspect of the prima facie elements in order to be able to prove the case. 632.7 is strict liability. If you record someone on a cell phone, it's done. There's no confident. That's why it's certifiable. Whereas the 632 cases, if you have some kind of policy to give a warning, it's going to be idiosyncratic to the call recipient.
Right.
So I think under the Kearney case, it's like, objectively what a reasonable person would presume that the call is not being recorded. So under that standard, what you perceive to be like reasonable under the scenario, like if you've had 4 calls, on the first 3 calls, they told you calls may be recorded, and then on the 4th they don't, the defense has a pretty good argument that you are on notice, right? Whereas in a cell phone case, because there is no confidentiality aspect, even though there is one district court case, the Nutrisystems case, that does put that notice requirement in it, I think that's against the prevailing law, at the California Supreme Court level. It doesn't have that requirement, and I think on the 632.7, you're much better to go on a certification.
All right, and you've got a secret sauce to get over because look, everyone's got the policy and the practice. They've all got the Queenie retained. They all know that they're supposed to be providing these disclosures, even in a setting where everyone's supposed to provide the disclosures. You think you can certify this?
Yes, because I'll tell you something, right? This is fact. In big corporations with pretty solid policies, you still have, on the inbound, you're never going to get past it because you have the IVR. Right. So that's not where you're trying to certify. What you're trying to certify is on the outbound call, right?
And they can't use a pre-recorded message because that triggers TCPA. So they have to use a live person.
Right. So
Way to go. You got the pincer. I got you.
So you got a human error. Right. So you got human error, but even with the most the biggest, with the most compliant companies, you're still going to get an 8 to a 12% error rate.
I agree with that.
So 8 to 12% on a company that makes, 50,000 calls into California every week, that's a lot of liability, even at 8%. The question is, can you certify the 8%? And I'm telling you I can.
You're using the call miner data, aren't you? I know what you're up to.
Actually, you're wrong.
I know what you're up to, boss.
You're wrong. I will tell you, off the record, but you're wrong.
Okay. Well, look, this is fascinating to me, and this is what makes these cases so beautiful. It's what makes a guy like Abbas such an intriguing character to me, because you've got these really esoteric legal issues. You've got only certain elements of data that you can utilize and other forms of evidence that you can utilize to prove your case, or in my case, disprove your case. And you have to think creatively in terms of how you can possibly leverage these things against the prevailing law. And of course, what's the most fun of all is creating new prevailing law. Yep. And hopefully, Abbas, you'll give us this credit, because I consider you to be one of the most creative lawyers out there. And I like to think of our shop as an incredibly creative law firm, which on the defense side, as you know, it is so reactive. I swear to God, everybody that's an attorney on the defense side is just constantly looking backwards, trying to play it safe, seeing what other people have done, and just trying to duplicate that so that they don't fall like short of some standard of care. Nobody's trying to win, right? I feel like we're the only ones out there like really innovating, really trying to win. And so going to the wiretap cases, for instance, which I just love talking about these things under 631, all these firms are arguing there's like this third party rule. If the web session is being recorded by a third party, then it's not subject to the statute.
That's been litigated.
It's craziness.
I mean, Smith versus Lone Me, put that to bed.
I mean, this whole thing is, to me, it's craziness, right? And we've got a perfect angle, which I'm not going to share with you, but I just think it's absolutely killer. Nobody else is thinking, right? That's what I appreciate about you. You're at least thinking.
I mean, you guys are very, very creative, and even in the TCPA round when we had more cases against each other, like you always were coming in with something new. And I totally agree that the defense is very, very reactive, as like, and I'm generalizing, not all defense counsel, but
I agree with that.
As a bar, I feel like it's very reactive. So let's go with Article 3, for example, right? So with Article 3, you get some good case law on your side, but then my question is, like, I mean, think about this, right? What did we just talk about? How defense firms' favorite play in their playbook is remove to federal court. Okay, you bring your Article 3 standing. Then what's going to happen? I'm just going to refile in state court, which is what you don't want in the first place.
Well, now we've had this discussion before. First of all, we see what happened with state court standing rules in Florida, right? I mean, that's bonkers. I mean, by the way you look at it, those cases are dead now in Florida, which is fantastic for the defense, right? I mean, it's a questionable, Elridge versus what's that, PetSmart or something?
Yeah.
That is a questionable, highly questionable doctrine. I'll hand that to you, but look, that's the law down there in Florida right now, so you can't deny it. I mean, that's a big win on a standing perspective.
1,000,000%, but that will never fly in somewhere like California.
I mean, it shouldn't even fly in Florida.
It shouldn't even, And the thing is, I respect you for even admitting that, right?
It's the truth. I mean, look, that's the nice thing about you two. You always kind of just admit when the law is not necessarily where it should be. Look, you know me. I believe in doctrine. Right? I am very rigid intellectually. I like things to apply the way the rules are written, the way that doctrine should be applied. So I look at Article 3, and ever since Spokio came out, right, the plaintiffs, the defense bar got onto the Article 3 bandwidth, in my opinion, because of me. Right? I wrote a blog the day Spokio came out that said this is the death of TCPA class actions, because Article 3 now, there'll be individualized inquiries as to whether or not there's actually concrete harm. You cannot just look at a statutory violation to establish Article 3 anymore after Spokio. And of course, it took 5 years before the first case decided, yeah, I was right all along. But for a long time there, right, the district courts just couldn't wrap their heads around the fact that the Supreme Court had just said, no, really, there has to be actual harm. And the Ninth Circuit, as you know, still arguably after Van Patten, that's still not the case, right?
No,
so
it's not.
It is remarkable, right, how long it takes for case law to develop. But the point is, like, we always try to be on top of everything, pushing those developments, and you definitely do the same thing on the plaintiff side, which is why it makes it so much fun to litigate against you.
I have a TCPA question for you guys.
Okay.
So, and this came up in Marks, right? And I still don't think a court has really answered this question. So, the Omnibus 2015 that the DC Circuit kind of like debunked, and it was pushed back to the FCC, and the FCC hasn't really responded to that
Correct.
still, right? Now, my question is, to the degree that the 2015 opinion incorporated some of its prior opinions in 2008 and 2003, specifically the 2003, is that overruled in your opinion? Or because, obviously my stance is that the jurisdictional limit of any circuit court was lost because the 60 days under the Hobbs Act came and went on 2003 and 2008, so they didn't have jurisdiction to overrule those.
Well, look, this is an argument I haven't had to have since like 2019. This is an old school argument.
But there's still issues within that 2015 that are not ATDS issues that I still think like deserve that discussion, and I still haven't seen a court rule on that.
Well, I mean, I think Chief Judge Edwards answered that in the ACA International opinion. I mean, the court said very plainly, that the plaintiff argues, or I guess in that case it was the FCC argues that the jurisdictional limitation of the review was limited to 2018, and I believe the quote is something along the lines of, "We disagree." I mean, ACA International came directly out and said, we will not confine our review. We are not jurisdictionally limited to just the action in 2018. We're going to review the previous action in 2003 and 2012. So I think, Abbas, I think that answer is in the ACA International
But do you agree
itself.
with it? Let's assume, let's assume it says that, right? Like, just on a very scholastic level, right? Don't you agree that under the Hobbs Act you only have 60 days? So, like, whether they agree or disagree, I don't agree with that, with what they say.
Well, I think honestly that question then, even if I agree with you, that question now becomes moot following PDR Resources, the new Supreme Court decision that basically says, one, is that a final agency ruling, which it probably is, but two, right, did the defendant that is trying to challenge the ruling, did they have a chance back in 2015 to actually say something about it, or in 2003 to actually say something about it, right? So if I'm a defendant, and let's say I've been in business since 2005, right? I'm obviously going to say, I didn't even exist in 2003, so how could I possibly be held to something in 2003? The only ruling that would be binding on me would perhaps be the ACA or 2015. But no, I don't disagree with you that if, assuming that the Hobbs Act bar stands, assuming that that doctrine is correct, so assuming that the PDR Resources requirements are met, I mean, again, doctrinally, I could see why you'd say, how does this court reviewing in 2018 have the jurisdiction to look at something that happened in 2003. Now, the ruling says because the FCC essentially stood on and readopted what had taken place earlier in time, and that was the reason why the 2003 ruling and the 2012 ruling were subject to further review. I tend to agree with you, though. If you read the omnibus closely, the FCC was aware of that, and as they framed it, the Bureau, whoever staff members wrote it, actually wrote around that piece, specifically saying, we decline essentially to reconsider, and will simply remind you that this has previously been determined. Look, it's a great point, but no one brings these ATDS cases in anyway. So why are we focused on this?
No, I'm just saying there's other issues,
Yeah,
and
sure.
I never felt like after that any court really touched that issue.
I agree with you. For what it's worth, I think there was like 4. It's not true that no courts have. There was about 4 rulings that looked at it, and then Facebook came out, and no one really cared anymore.
True.
And those 4 cases did kind of split at the district court level. So let's get to a couple of more important things. Like, I hear you're taking ice baths now or something. I don't know what
So I'm actually thinking about getting an ice, like a temperature controlled thing for my patio. But I go to cryo, cryotherapy.
I keep hearing about this cryo thing. Like, what is cryo? I'm not going to get in an ice bath. I'm telling you right now.
So a lot of these medical experts are saying that. I have a sauna in my house, which I do regularly, because this is a fact. So statistically, men specifically, but women too, that do saunas at least 4 times a week reduce their probability of dying from heart disease by over 50%.
I feel like that's a made up.
It's not. Look it up. Look it up.
Look this up. I think it's a made up.
Look it up. And then cryotherapy obviously is great for inflammation. And
why is that obvious? What do you mean that's obvious?
Well, when you get a bruise, what do you do?
I try not to get a bruise, man.
You put ice on it, right?
I guess in theory. I
don't think anyone's going to debate the inflammatory benefits of cryotherapy. But now this has not been medically proven, but I'm a big proponent of it anyway. Is that obviously when you go in there, it has a lot of health benefits, and specifically it's helps increase your metabolism, increase your calorie burn count per hour or something, and I think there's a guy called Gary Brecker. I'm not an authority on this. I'm just telling you what I see on TikTok. So, but I like it. Makes me feel good. And then the guy says, well, what's the definition of a calorie? It's like energy. It's heat. Yes. And so, what's the and he claims that. And this is the guy, by the way, that basically trimmed down Dana White and is the guy that's allegedly took away his diabetes and reduces cholesterol with the diet and the regime he's got him on, which is massively to do with doing ice baths or cryotherapy. And Joe Rogan, by the way, if you ever watch his podcast, he's a massive proponent of cryo.
This guy's podcast is very weak compared to ours. I don't watch anybody with a weak podcast.
The ratings prove that.
Yeah, thank you. I'm glad that you recognize that. So pivoting off of that, thank you for the cryo. What do you think, Pooja? Are you going to...
Oh, not a believer. All you have to do is follow Queenie's exercise routine and eat as well as I do, and you'll stay healthy.
There you go. And a couple of bourbons a night doesn't hurt either, I wouldn't say. That's a joke, maybe. A couple more topics, and then we'll let you get out of here.
Is that when you send your emails.
Yeah.
TCPA World After Dark.
After dark.
Every time an After Dark post goes
the
up.
After Dark are the good one. It's so funny because so many people read the After Darks. And I swear they're like different populations. Like I don't use like Google Analytics or anything to like really parse, but I'm really very curious because if you see like trends in terms of who's looking at the TCPA World After Dark articles, it's like one group of people, and then the actual articles is something totally different. But anyway, AI, man, generative AI, ChatGPT, threat to the world or super cool and you're on top of it, going to kill the legal profession or can be leveraged. What do you think?
Wow. So we're very early days, right? And so I'm a big proponent of AI, but I use it cautiously. And I mean, I'm not trying to, I'm not getting paid for this or anything. Like case text, for example, that just got bought up by, I think, Westlaw.
Thomas Roosters, yeah.
Yeah, like I use them and like, for case research, not that great, but for like contract review and like doing little memos and stuff like that, that would give you the premise of something, at least as a foundation, I think is very, very good. Where that's going to be in 5 years, I think is going to blow our mind, right? Now, I think a firm that's running, let's say, on 25, 30 lawyers like mine, I think in 10 years we could probably run with 5 to 10, right? Like that's what I believe. I think someone like you guys, like me, are not in danger of losing a job, but I think there are people that are pumping out memos, briefs, and stuff like that. Like, I mean, you're not going to substitute oral argument, trial practice, and things like that. But what you are going to be able to definitely reduce in bandwidth, like, or get more out of your staff with AI in maybe 5 to 10 years, is writing real briefs. Like, whether it's summary judgments, oppositions, or moving papers on 12Bs or 12Cs, whatever they may be, and appellate briefs, of course. I think AI is going to get that sophisticated. It's not there yet. And so I don't think our jobs are in danger, but if I were going to law school between now and the next 5 years, that's certainly something that I would be very vigilant of, because I think AI is definitely moving in that direction. But right now, I'd certainly be very, very cautious trying to use it to write briefs or use it for authority. I think it creates some foundational tools for us to work with, but it's definitely not there.
What about reply briefs? Do you think they'll be able to plug in, chug?
I think that's in 10 years. I think they'll be able to write moving papers in probably 5, and maybe quicker even. I mean, it's crazy how technology moves. 3 to 5 years, I think they'll be able to write pretty solid briefs or at least do good legal research. I mean, already you have technology that exists that you get a brief that will shepherdize every case in that brief. Right, that exists. So that's already there. So you have to move 2-3 steps further. To the degree to do reply briefs, I think we're about 5 to 10 out on that.
So reply briefs before or after it gains consciousness and wipes out mankind?
It's going to be tight.
It's going to be tight. I agree. That's really the over-under. Really is before. Yeah. So look, I'm going to take a stand right now. Troutman and Mean, I'm going to just tell you right now. Love it or hate it, we'll never use AI.
Nope.
We'll never. So long as I live.
Not allowed.
Right. And so long as I'm in control of this firm, we will be a naturalist shop. We will not have any AI. We're going to be writing briefs the old-fashioned way. And I get it, right? Like there's going to be some people that will say, well, Troutman, you're a dinosaur. You're going to go extinct. You know what? I have built a practice on hard work, on judgment, right? On human judgment, which no AI machine can ever replace. I'm sorry. It can be nuts and bolts. It can use whatever language modifier and creation generator engine it wants to use. It will never develop judgment. Even if it develops consciousness, it will never develop judgment. And I will not replace that, even at the lowest level of my associates, not even at the paralegal level. I will not replace that with the machine. Never. The human element of trust is the backbone of the attorney-client relationship. Will never be duplicated, and I'm telling you right now, so long as we're in business, we will not use that stuff.
That's pretty cool. I agree with 85% of what you say, but I'm never going to be unequivocal in that position like the way you are. And I respect you for taking that position, but I mean, you have to also talk about efficiency, right? And so you get paid by the hour, whether you're right or wrong.
It's true.
And I don't. And so on an economic level, when you're trying to enhance your bandwidth, and if the technology is there and it's proven to be efficient and it's working, and right now it's not. I totally agree with that, right? But when there were people that say, I'll never use email. Yeah, I mean, look at where we are. And that's a crude analogy, but I think in 5 years, you may have a very different position.
I'll be John Henry swinging the hammer against the steam engine until the day I retire, man. And
Yes, you do understand he still owns a BlackBerry. We're in the BlackBerry building. He has a BlackBerry phone, okay? With the keyboard and all.
And an argument could be made that actually the practice of law was superior before emails existed, right? I mean, every step in the human progress technologically, especially in a profession like the law, right, where we're essentially speeding up as opposed to slowing down and being more contemplative, deliberative, and thoughtful, it's not good in the practice of law. Introducing technology that speeds you up, that enhances efficiency, again, over deliberation, this is not a positive development in my mind. So again, would I say I wouldn't use email? I don't know. Maybe I would have said that back in the day. But I'm sticking a fork in this thing right now, and I'm saying I'm not going any further. There will be no AI, not in this shop.
Well, how far are we from judges, federal court judges, asking AI who's right, who's wrong?
Yeah, I mean, why not? Like, if the AI is writing all the briefs, why not have the AI make the determination as to which of the two briefs is superior?
If that happened, there wouldn't be such controversy over confirmation, then, would it? Because you'd actually be getting the law back.
Well, maybe not. Yeah. But then who's writing the program, right? I mean,
Yeah, it's always going to have a slant on it, right?
It's always going to have a slant. And
that's true.
And this is, right, it goes back to real human judgment, which, it's just like the umpires, right? You put the umpire up there, they might get a strike or a ball wrong once in a while, but to me, I don't want to see that get replaced by the little fake box with the imaging. I want to see that human being. That's part of the game of baseball, and so it is with the practice of law and with the justice system. Right? Justice, again, is a human concept. It's a human concept, and a machine will never grasp it, no matter how sophisticated it becomes. The idea of justice is imbued in you want to call it the human soul, whatever you want. That part of us, the animus that makes us what we are, we need that, even if we ultimately disagree with that judge, that woman or man who's making the decision, knowing that they are operating in good faith and using that part of them that makes them human, that will always have credibility with humans, never a machine, in my opinion.
I think on a theoretical level, I totally agree with you. You see, where you are, the part of the evaluation that you're kind of missing is where you're going to be at a competitive disadvantage. Because let's fast forward 5 years. Your competitor is going to go, hey, such and such bank, I know Troutman, is a really, really great firm, but I'm going to do the work for this much less because I've got a computer running it.
I agree.
And if you're okay with it, we're going to do that.
I agree.
Right?
I agree.
And so you're going to lose business.
Yes, I will.
So,
that's a fact.
Yeah.
I'm going to lose business from this podcast, right? Because there's going to be some people that say he's not innovating. But I'm telling you right now, we innovate using our human minds. We don't innovate using the AI to do our thinking for us. To me, that's an abysmal fact. But I agree with you. And trust me, especially with the big banks, right? These commoditized entities that are just looking at the bottom line, not thinking big picture. Oh my God. People like us are going to get creamed. We're going to get creamed. But at the same time, right, we're going to stand with our clients who are loyal, who trust our judgment, who recognize that the practice of law is not commoditized, right? It's not just who can do it for less. That's the exact same race to the bottom mentality that led to the TCPA world explosion back in 2014 and 2015, where everyone just handed it off to the law office of whatever terrible firm would take the case for the least money, and look what happened. People got destroyed. And it's going to be the same thing as people start shifting to AI.
That's what happened.
Yeah. I mean, talking about a case that should have never been certified, man.
How dare you?
Dare I? And with due respect to you, Judge Houston, I respect you very much, but that case should never have been certified.
That case gets cited an awful lot.
Yeah, I'm sure it does. A text string class certification. Come on, get out of here.
Brilliant.
Boss, you are brilliant, man. I love having you here. We can talk to you forever. Queenie, I'm going to give you the last question here. We got to get this guy out.
I have to. Well, I have been seeing an uptick in your TCPA filings in the last 2 months. So don't think I'm not watching you. I am watching you. I am curious. Are you going to be filing any of the mini TCPAs?
Oh, yeah.
It's
not in Florida.
not in Florida anymore.
I mean, Oklahoma, if I get one, I'll definitely do it, right? But I'm still, Utah still hasn't gone into, been enacted, to a degree where I'm comfortable with it.
New Jersey and Washington, though, pretty attractive.
Yeah. Have they been
not to give you any ideas. Actually, I'm going to withdraw that last comment.
Redact.
We have an office in New Jersey, so I should be looking into that. I appreciate that.
Well, look, man, you're an incredible litigator. You're a decent guy, notwithstanding the fact that you've just chosen to be on the wrong side. But, again, I'm a guy who really respects people, the Horatio Alger background, coming from nothing, building themselves up. And I love that story and I actually know exactly what Seattle's best coffee. I don't think it's there anymore.
It's not. It's something different now.
But I think I used to go there around that same time frame. It's right there next to the Bruxies in that complex. It's amazing to hear that story, man.
Thank you.
And honestly, although I would never wish you success against any of my clients, I continue to wish you great success. You're a great guy. Thanks for being with us.
Thank you so much for having me. Really appreciate it. Congratulations on the new digs, the practice. You guys rock. Keep doing what you're doing, and hopefully we'll see each other in court soon.
All right. How amazing was that? And welcome back, everyone. Like, through the magic of television, all these folks are just back all of a sudden. They just materialized. Abbas Kazerounian, I love speaking to the guy. He's absolutely brilliant. He really helped to create the TCPA world that we know it now. I think just like Josh Swaggart, he's moving on. Swaggart's really into CIPA right now. We heard Abbas talk about the different kinds of cases that he's moving into. Obviously, Troutman Amin is being dragged out of just doing TCPA, and we're doing the privacy work and the CIPA work now as well. I think it's a natural progression. Let's start around. I'm going to start with you though, Pooja, because you just did the interview with us. I mean, what were your kind of takeaways?
Well, you always know that I've always thought Abbas to be extremely wise. Recall we had him live in person when we had the beta version of TCPAWorld, TCPA Land, and he came in live. I think it was shortly after the Marks decision, if I recall correctly.
That's right.
We may have had him a few times on the podcast previously, but folks, what we didn't talk about much was that he was the genius, if you will, behind the Marks decision, right? Like he created, well, he created that law, right?
He did.
And so, TCPAWorld goes way back with Abbas, and it is interesting to see how he's pivoting similar to how Josh is. What I did really appreciate was that he's not following those 631 claims, right? He said that he thinks they're bogus, right? And that truly should tell folks that, like even the most intelligent plaintiffs' attorneys, even though they know they can probably, get a buck or two out of it, he's not approaching them because he thinks they're nonsense. So I appreciated his insight into that.
I have to get his playbook on 632 though. I'm very curious. 632.7, he says there's no additional requirement on confidentiality, strict liability. That guy's smart, but I am curious, how do you prove that the procedure was not being followed on a class-wide basis? I am intrigued. We'll have to find out. All right, what did you think, Baroness? So everybody, while you were watching us, the team was back behind the cameras watching as well. So they've got some insights here as well. So we're going to start with you, Baroness. What did you think?
I thought it was just fun all around. I mean, it looked like you guys were having a great time. Typically, I don't always enjoy the interviews because they just go for so long.
Baroness is dropping the bomb.
Wow.
No, but I'm saying I really enjoyed this one.
Get better guess, Eric.
Kira, can you get the severance papers together for her, please? Thank you.
No, I really enjoyed it. You guys covering the CIPA, like my ears perked up because I'm really looking at those cases too. And also when you talked about the napkin contract, that really hit home to me too because...
Why is that?
Because I joined this firm, my contract was on a napkin at a bar, and...
Where else? I mean, come on.
Napkin contracts are important, so...
It's fantastic. No, I loved hearing the story of Abbas starting off in that coffee shop. I mean, it's really impactful. I mean, people look at a guy like him, and they, you hear some negative things. They call him different names. And don't get me wrong, like, he's chosen a path that I wouldn't walk. But you have to respect a guy that started with nothing, that worked incredibly hard, that literally was engaging people on a napkin, which I think is binding here in California. Honestly, I don't know. Probably. But no, it's incredible. It's an incredible thing. Tori, what did you think?
I thought this was our best interview yet.
Well, thank you very much.
Yes.
Oh, it's because Pooja participated.
No, I just think all around it was probably one of the most interesting. I like the competing views of AI, especially now that I've been delving into that world. And I love the story of the humble beginnings always. So that was really, really enjoyable.
Tori, what are your thoughts on Troutman and me not using ChatGPT?
Oh, I'm perfectly fine with that. I completely agree with that.
I thought you were going to ask what's her thoughts on the Viceory joining the firm. Joe, so you're standing behind me. Through the magic of television, it's going to look like I'm facing you right now. This is called cheating, where I turn my body toward you when I'm not really looking at you, but the camera thinks that I am, even though I'm not looking at you, Joe. What do you think?
No, I think I'm with Tori. The AI conversation is going to be critical in the days, months, years to come. I like our stance on it. I'm fully of the mindset that doing human work, not using a shortcut, is the way to go. You can always be confident that what you're going to get is a solid work product. And again, I can respect Abbas's view where you have law firms that are going to downsize. They're going to get rid of 50% of their workforce because they have AI doing the brunt of the work for them. And I mean, to me, as a potential consumer, if I ever need an attorney, that would be a factor I'd want to pay attention to. You know, am I going to want a law firm that uses a computer to do their analysis, uses a computer to figure out some arguments, or what's their statistical likelihood of winning an argument based on what a computer generates, versus, you know, an attorney who has a conversation with another damn good lawyer and says, hey, I think this can work. No, this is the pitfall here. Let's try this. Oh, that's a good idea. Or spitballing something. That's something that, you know, myself, Tori, we've done in the past. I think it's a very useful method in order to practice law. And that's where I fall in it. But I think it's going to be really interesting to see where it goes.
What do you think about Abbas generally? Decent guy, scumbag, somewhere in between?
No, he's a great guy. I mean, I don't know him very well, but he seems very genuine. And again, as someone that came from a blue-collar family myself, I really have to tip my hat to him for making as much out of himself as he has.
Well said, my friend. And last but not least, certainly not least, never the least, even though she has fallen a couple of rungs, the wonderful Duchess. How are you, Duchess? What'd you think?
I loved the energy. I have to agree with Brett. I love the energy. I really enjoy kind of listening to two intellects just kind of talk. Just you guys just flow so well together. That was really enjoyable for me. I mean, I wish we would have gotten just to state laws just a little bit more because, you know, that's my jam. I love that. But I love the podcast. It was great.
Well, thank you very much, and thank you for referring to Pooja and Abbas's intellects. I don't know where I fall in that mix, but look, let me just wrap up by saying, I mean, I know a lot of you have detected that I've got good relationships with these plaintiffs' lawyers. You know, Abbas and I literally go back a dozen years now, almost longer, or perhaps longer. And you know, there's a reason that I try to maintain these relationships. Obviously, it's very helpful in litigation when you can pick up the phone and you can just, you know, play very straight with somebody and tell them exactly what the facts are, exactly what the strengths of your case are, and really kind of lean on them to understand why it is that a case might not have merit. And being able to have that lengthy relationship and that credibility, I think, is critical. Plus, I mean, being able to respect your opponent and really understanding what they're capable of is the first step toward you really being in a position to deserve to win. If you're going to be underestimating the people that you're going against or not really understanding their game, truthfully, you're not going to survive here very long because you are going to get taken to the woodshed and you're never even going to see it coming. So hopefully all of you appreciate that although we can have Abbas on here, we can have some laughs with the guy, we can really kind of break in and compliment him because he deserves to be complimented. Nonetheless, when necessary, we are the fiercest of adversaries, make no mistake. And I am going to get that information about 632 and I'm going to share it with all of you. It's a secret. I'm just kidding. But you know, for all of us, I really deeply appreciate you tuning into this, our 14th episode of Deserve to Win, and we'll see you next time. Bye, everybody.